Hey guys, I want to share with you a few policy changes and updates that you should be aware of. Now, we have been discussing many of the changes that have occurred with this current administration. So, the first policy change I want to share with you is that starting November 1st, immigrant visa applicants, they must interview at the U.S. consulate in their country of residence, or if requested, in their country of nationality. Now, U.S. Department of State has said this new rule applies to all immigrant visa types. So that's going to include family-based visa applications, employment-based visa applications, in addition to diversity visa lottery winners. Now, there is an exception, but it's in rare instances, and it's limited to if you need to interview at a different U.S. consulate because of humanitarian or emergency reasons. Now, some countries currently do not have a functioning or an open U.S. consulate, and for those countries, Department of State has designated an alternate processing post to ensure continued interview operations continue underway. The second information or policy update I want to share with you that's been announced for September is that USCIS, DHS Secretary Noem, has issued a final rule where USCIS, that agency can now carry firearms. They can execute warrants and they can order expedited removal. Now, USCIS, traditionally, as we know it, functions as the agency that processes applications and petitions, green card applications, and things of that nature. And so traditionally, that agency has not been the enforcement side of immigration. But now with this final rule, it does introduce a blending of the two roles that USCIS traditionally has played with an enforcement role. Now, this new change is slated because of the need to help cracking down on fraud and working logistically with the enforcement side of immigration to coordinate other enforcement efforts. Now, here's what you should know. As far as the immigration law with regards to being able to sponsor a family member, the immigration law remains the same. Congress hasn't changed that. Applications which require a measure of discretion, that still remains the same. However, as I've shared with you in other videos, it is going to be extremely important for you to assess what risk factors, if any, you possess in your immigration history, your immigration application. Because if you are someone who has a prior removal order, you are at risk. If you are in current deportation proceedings, that is also a risk factor. If your sponsoring spouse had a prior I-130 denied because lack of bona fides, that too potentially can be an area of risk. So you want to be sure that you work with a licensed immigration attorney to risk assess. And the third piece of policy update that I want to share with you is that we've talked about in this current administration, several immigration judges have been terminated and or resigned. And so there is currently a shortage of immigration judges to adjudicate the 3 million plus applications that are currently pending. Well, guys, let me share my screen. And as I do so, let me just say, the Pentagon has authorized to send up to 600 military lawyers to serve as temporary immigration judges. Now, there's currently, as I said, a shortage. But guys, let me just share with you, critics of this decision are warning that this decision could very well undermine due process, in addition to the fact that the military lawyers not being trained in immigration law. And so this definitely can result in a miscarriage of due process um, because of the lack of experience. In this article, I want to share with you a segment here where it says, the training that goes into being an immigration judge. And this is referencing a former judge where it starts off by saying here, until she was abruptly fired in July, former supervising judge Jennifer Payton administered the intense training that all judges in Chicago undergo before working in some of the busiest immigration courts in the country. After the weeks-long training, new judges are paired with an experienced mentor and have a 2-year probationary period. Payton doubted that military attorneys would be able to master the complexities of immigration law without that rigorous process. She also said that it wasn't clear how they would handle the hundreds or sometimes thousands of cases on just a Chicago immigration judge's docket each year. 6 months is barely enough time to start to figure out the fire hose, of information and training, she said. Payton also was concerned that Trump's move didn't supply more administrative workers, including translators, whom judges rely on to make decisions. The stakes, she said, were life or death for people who would come before new judges. None of it makes sense unless you were intentionally trying to weaken the immigration courts, Payton said, and I will stop sharing there. So guys, with that bit of information, it is important to note that if you are someone who is currently has an immigration case at any of the immigration courts across the country, you want to be sure that you are working with a licensed immigration attorney because so much is happening, and having attorneys who are not familiar with the immigration court system, the immigration laws, the policies, the regulations, that most certainly could potentially have an impact on someone who has an application pending in immigration court. Guys, I do thank you so much for watching. Please be sure to like, share, and subscribe. I will definitely see you guys in the next one. Bye-bye.